Hi again. Welcome to another episode of Ask the Lawyer. This time we're going to ask, what do you do if you fall, if you get hurt on someone else's property? Do you know what to do? Well, luckily we have a guest here who does. I'm Rob Rosenthal with AskTheLawyers.com. My guest is Tyler Bailey of the law firm of Bailey Law Firm in South Carolina. Tyler, thank you for making some time for us today to answer our questions.
Well, thank you for having me.
So let's talk about what we in general call slip and falls. Is the process different when it comes to talking to an attorney, whether it happens at a business or at another private residence or somewhere else? Walk us through that.
Yeah, well, the process is really the same as far as any person's conversation with a lawyer regarding the next steps. Now, the law is a little different, or there may be some different intricacies with the actual case, depending on if it's a private residence or if it was a fault that happened in a public park. But as far as the client's concerned and talking to a lawyer, the process is exactly the same.
How badly does someone need to be injured before they need to get an attorney involved?
You know, if somebody's injured, period, if they fell somewhere, generally speaking, they need to get an attorney involved. Unfortunately, the law is very tricky when it comes down to slip and fall cases. So a lot of times, business owners, property owners, people who own the land, whether it's public or private, they try to get out of being responsible for your damages, your medical bills, and your pain and suffering that you suffered as a result of the fall. So it's important that you get a lawyer so they can actually bring your case, and they know the law, they know how to bring it for you. If you try doing do yourself, you're more likely going to fail.
You mentioned, especially at a business, say someone falls, they're injured at a business. A lot of times they're going to hear from that business or a representative of that business the next day or maybe later that day. And is it important that they maybe don't talk to them or at least don't agree to anything or sign anything until they talk to an attorney?
Well, they definitely shouldn't sign anything. They definitely shouldn't agree to anything over the phone either. The most they should do over the phone is get all their contact information, mailing address, phone number, get the name, first and last name, whoever you're speaking with, the claim number, their email address. Once you gather that information, it's safe to cut the conversation short there. Then you can contact a lawyer and give that information to your lawyer and allow them to handle all future conversations.
What if, say, it happens at a restaurant and the restaurant owner says, hey, or the manager, we're going to comp your meal, don't worry about it. Does that affect your case at all? If they comped your meal, is that a problem?
Well, you know, generally it's not a problem. You know, as long as you're not signing anything, okay, saying that there is you're releasing your right to bring a claim for your fall. If they want to try to comp it, want to try to rectify it, that's going to look better on their part, but still is not going to prevent you from bringing a claim for any pain, suffering, or medical bills that you have. A free meal is nothing compared to $1,000 worth of medical bills from a fall that you've had. So we're not talking apples and oranges here. It's something completely different, and it's not going to affect the case.
What about compiling evidence, for lack of a better term? You know, we talk about in car accidents, take a lot of pictures. Is it similar in these kind of situations? Before you leave the scene, if you're not rushed off in an ambulance, to take pictures of what the scene is like?
Yeah, it's a good idea to take some pictures, also get witness information, get their names, get their phone numbers, make sure you go ahead and reach out to them early so they can be on your side, because a lot of times the business owner, let's say it's at a restaurant, they have the surveillance footage. They're not going to give you that information immediately. And if you don't have anything available, a picture of what you fell or what caused you to fall, any witnesses, it's going to be pretty difficult to bring your case. So it is important that you gather as much information as you can. Ideally, try to get an incident report from the restaurant or business or wherever you fell at, get the witnesses' information, and then give that information to your lawyer.
You mentioned surveillance footage and that sort of thing. I would imagine having an attorney who can quickly act to make sure that kind of stuff doesn't mysteriously disappear is a good idea too, right?
Oh yeah, that's a great idea, and that's what I always do. I immediately send something called spoliation letter, which pretty much tells them to preserve any surveillance footage, any records they have regarding the incident, and then once the case can start, I ask that they give me that information immediately, so we have all the information exactly how the fall occurred.
Is it hard to prove whether it was due to some sort of negligence or well, they were just being clumsy? Is that difficult when you're figuring out whether a case has merit or not?
Well, of course, the business owner or property owner is always going to say that it's the fault of the person who fell. But I mean, with witness information, photographs, history of prior falls, I could bring a case. A good personal injury lawyer can bring a successful slip and fall case. there's a incident report that you can give to your lawyer. There's ways that the case can be brought and you could actually recover for your damages. Unfortunately, it's really hard for people to do it on their own. So it's really important that they contact a personal injury lawyer that knows what they're doing with these type of cases.
What does the law say about when a property owner should have known about a dangerous condition on their property? Do they have to have been told about it? Walk us through that a little bit.
Well, no. So the property owner doesn't have to be told that there's a dangerous, something dangerous on their property, but they knew or should have known. For example, if you have your house, you may know a certain area of your house, there's maybe a certain creek when you step on a certain part of the wood. Property owners, they know how their property is. A visitor going to the property does not know if a certain area is dangerous, if there's a leak somewhere, and during certain times of the day, the floor is wet. So property owners should know. They either knew or they should have known about certain defects on their property. So if somebody's injured as a result of that defect, the property owner is responsible for the person's injuries. And
if someone calls you or your firm for this sort of thing, Tyler, is there a charge for the initial consultation? Do they need to be prepared to have some money come out of pocket up front?
No, so we don't charge anything for initial consultation at all. And also there is no fee that's applied unless there's a successful recovery at the end of the case. So there's really nothing that somebody has to lose in contacting my office if they've been injured in any case or if they slipped and fell out of a property.
What should they be prepared to provide you in that initial consultation? Do they need to have medical records, receipts, pictures? What do they need to have with them?
The more information, the better. But if they come and they don't have any information, they just, they can just say the date it happened, where it happened, any incident report that they had, we can recover everything else. But ideally, in a perfect world, if they had medical records, incident reports, witness information, and more documentation like that, it will be easier for us in the beginning. But I like my clients to have to do as little work as possible. So if they come to me with nothing, we'll take care of everything else.
But and like we say often, sooner is better rather than later.
Sooner is better than later. Immediately. As soon as you're in a position to contact a personal injury lawyer after you've been injured, you should do so.
Lots of great info as usual, Tyler. Thank you for taking some time to answer our questions today. I do appreciate it.
Oh, my pleasure. Thanks for having me.
That's going to do it for this episode of Ask the Lawyer. My guest has been attorney Tyler Bailey of South Carolina. If you want the best information or you're ready to choose a lawyer that lawyers choose, be sure to go to askthelawyer.com. Also, please take a sec to like, share, and subscribe to our YouTube channel by clicking below. Thanks for watching. I'm Rob Rosenthal with AskTheLawyers.com.